No one is there. Bracket हो दिया अपने के रे. बाकी के तो कॉल कर दे.
Item number 29, bail application 427 of 2024 and item 30, bail application 520 of 24.
Petition dismissed. Court below is directed to conduct day-to-day trial.
Mention in this.
Same petition dismissed.
May I plead the Lordship?
Yes.
I beg to mention item number 2, 20. Case is not received.
Yes.
CD not received. Lordship.
CD.
Not received. There is no interim, my lord. Therefore, may I pay for next week?
Pardon.
There is no interim order. May I pay for next week? 1st of May or
Ms. Anders learned additional PP submits that she has not received the case diary. Accordingly, it is provided that Ms. Dassel produce the case diary before this court on
2nd of May, Lordship.
2nd of May.
Lordship.
2nd
2nd.
of May.
Okay.
Okay.
May it please the Lordship. Lordship, I beg to mention item number 9, Lordship. This matter may be passed over for the day only, Lordship.
On the appear being made by Ms.
M. Nidola, Lordship.
Learned counsel appearing on behalf of
P. Bordolo, Lordship.
Mr. P. Bordolo, learned counsel for the applicant. Learned counsel for the accused. Races is the matter on
Next week, Lordship, or this week, Lordship. May pass over for the day only, Lordship.
when?
Yes, Lordship.
Wait, please, sir.
Obliged.
So for item number 17 is concerned, my learned friend that informed me that CD is not there, Lordship. I am in interim, Lordship.
Okay. Madam CD not received.
CD not received, Lordship.
Ms. Anders learned additional PP submits that she has not received the case diary. Accordingly, it is provided that Ms. Das shall produce the case diary before this court on
On Lordship, 16th of May, Lordship.
16th of May. Mr. Ardhor, learned counsel for the applicant, submits that this court was pleased to grant interim protection to him until receipt of the case diary. Said interim protection may continue. Here is accordingly allowed.
Obliged. May it please your Lordship, I beg to mention item number 32.
30.
I believe the case diary has not been received.
CD not received.
32.
CD not received.
Is same order? Ms. Das.
Lordship,
uh,
Lordship.
When? Next that?
On Lordship, 21 May, Lordship. 21st May, Lordship.
No, this is BA. BA or AB?
AB.
I'm on
AB.
interim, Lordship.
You are on interim.
Interim, yes, Lordship.
Okay, sorted, madam.
On Lordship, then 17th May, Lordship.
17 May. Till then, interim order pass earlier shall continue.
Watch obliged.
Please, your Lordship. I
Yes.
just to mention item number 3. Kindly pass over the matter and make fix it 24.
On the pair being made by Miss
Ye Kolita.
K. Kolita, learned counsel for the applicant. The case is then adjourned for the day. So do we fix it at
24.
24? Yes, madam. CD available.
Motion,
Oh,
Lordship.
motion. Okay.
Publish you, Lord.
May I please, Lordship, I beg to mention for listing for any bail application number. Rule to mail.
When?
Day after tomorrow.
Okay.
Please, your Lordship, I beg to mention item number 25. Kindly attend the matter for 1 week.
What is your name?
S. Mahanta,
Ms. So-and-so, learned counsel appearing on behalf of
H. Burva.
Mr. H. Barua, learned counsel for the petitioner. Rest for listing the matter on
Next week.
On 29.
29, pair allowed. Is there any interim order? Okay,
Please, your lordship, I beg to know, item number 6, lordship, matter may be fixed on tomorrow, lordship.
is anybody for any objection? No. Ms. Dekar, learned counsel appearing on behalf of Mr. S.C. Kayal, learned standing counsel for the NCB with consent from the other side. Rest for listing the matter on
Tomorrow.
tomorrow. Okay, pair allowed. Yes,
Acha. May I please your lordship, item number 15, your honor. The matter may
item number
15. 15, CD is there. 15, your honor.
15.
Yes, your honor. 15. Case very received, lordship. The matter may be kindly adjourned for 1 week.
1 week. Your good name, please?
M. Chaudhary.
Ms. M. Soduri, learned counsel appearing on behalf of,
Or Soikia.
pardon?
A. Soikia.
Mr. A. Soikia, learned counsel for the applicant. Rest shall list the matter on
3rd May.
3rd May.
CD
Okay.
be written, lordship.
Till then, CD will retain.
My lord, I beg to mention item number 16, my lord. And I was told, my lord, that CD has
CD
not
not
come.
received, lordship.
Okay, Ms. Endas learned
Interim
additional
is there,
PP
Lord.
submits that she has not received the case aid. Accordingly, it is provided that Ms. Das shall produce the case diary before the court on
15th of May, lordship.
15th of May. Are you on interim?
My lord,
Interim is there.
I am on it.
Mr. J.I. Barbuya, learned counsel for the applicant submits that the applicant is on interim protection.
And I have deposed my statement also.
Okay. Let the CD come. See. Till then, interim order pass earlier shall continue.
My lord, but I beg to mention item number 10, my lord. Overall, the CD has not been received.
CD not received.
My lord, my only problem is that, my lord, my wife is in the, my lord, ICU. So a short date may be given, my lord.
For that, lordship.
My wife is in the ICU, my lord, at Sanjeevani Hospital, Dibrugarh, my lord.
Is there any medical document? So what is the source?
420, my lord.
How long you are behind the bar?
I'm behind the bar, my lord, 16th, my lord.
7.
So from where the CD will come?
Lakhimpur.
Lakhimpur, lordship.
Ms. Endas learned additional PP submits that she has not received the case diary. Accordingly, it is provided that Ms. Das shall produce the case diary before this court on day after tomorrow,
Lordship, I will try, lordship. Lordship.
day after tomorrow. You keep this certificate
have
on.
I have to
Okay. Okay.
Diplo.
It is your lordship. Lordship, your CD may be called for.
Yes, madam, go ahead. From Dokmaka PS.
Document station.
On lordship,
Or is that?
2nd of May, lordship.
No, 2nd of May will wait too long.
On lordship, 29.
29th. Okay.
Item number 2.
In this case, my lord, the petitioner, he obtained a diploma of dental mechanics from Lucknow. Then, my lord, he is working in the chamber of one dentist doctor as his assistant. So there is some professional rivalry Your lordship kindly see FIR page 12. One doctor, he lost this complaint. Lost his FIR. So accordingly, the petitioner, he was arrested on 1/4. It is alleged that although I am not a dentist, I am practicing, but it is actually false allegations, my lord. I was working under Dr. Ranu V. Thomas, BDS, under his chamber.
Lordship,
So
kindly.
I have been arrested. My statement has been recorded, my lord. All document has been seized.
Grounds of arrest kindly pays lordship, para 5. CD is required, lordship.
I am a doctor. I am
Which
not a.
point?
Page 14,
It is a point
para
request, my
5,
lord.
ground of arrest.
I am not dentist. I am more under dentist Thomas Rao.
Accused person doesn't have this qualification, BDS, lordship.
One doctor lost FIR against another doctor. I am more under Dr. Thomas. He is a BDS. I am a dental mechanics. I assist him.
But the allegation is that you practice.
Yes, correct.
Yes,
It
lordship.
is illegal. But my statement hasn't recorded. I am recorded my lord.
Let the city come
Let the
sort that.
city come,
I am on
lordship.
29 my lord.
29,
29.
Was I?
lordship,
Okay, 29.
lordship.
Item number 4.
Four 38 applications
Hmm.
against the so-called husband, mother, and two married sisters. Married sisters' husband was already, he is serving. On the particular day of incident, he was in the duty. There is a document to show.
He was in.
He was in duty. And he was
Where?
performing duty in Golpara. So far away from that place. So therefore, the alleged incident is a false incident. My submission is a
Where is the FIR?
FIR at page 14.
What is your submission?
My submission is that the 438 application, what is it called? 498 A application, sections. So therefore, the 498 application, these days it is liberally construed. Therefore, at this stage, I may be allowed to go on interim relief. Against the mother and two sisters, married sister, they are not staying in that home. Elder sister is, she is serving at Thubri. It is 6 hours journey from that place. Therefore, the incident, alleged incident is a wrong incident, or it is falsely stated. And we have the document to show she is serving in a school on the particular date of incident. And except 2,
No, there is allegation for
Rowdy.
this physical as well as mental torture.
Yes.
Is it not possible to subject her to mental torture from Dhuri?
In that case, first of all, whereas there is no marriage, formal marriage is not there. She has been staying without any authority.
Hmm.
No marriage. It is not a living relation also. So question of assault, question of mental torture, all those things will come.
You see, the accused disclosed that he prepared the aforesaid currency note in his residence.
No, my lord.
Thereafter,
The FIR
police
says
visited his house and recovered
one packet of white, my lord,
yes.
papers,
Mm.
my lord, and thereby the police, my lord, presume that it was used for manufacturing of, my lord, the false, the fake currency.
Mm.
But there is no, my lord, printed machine, nothing was recovered
Mm.
from the house of the accused person. Absolutely on suspicious ground, my lord. Because if he is, my lord, use it, my lord, the white papers, the bundle of papers, my lord, then there should have been, my lord, a printing machine also for get it printed, my lord, for using it or for, my lord, circulating it. That is not there, my lord. Only thing is, my lord, in possession, yes. Some amount of, my lord, fake currency has been recovered from my possession. That is admitted by the which attracts section 489C of, my lord, IPC, which is available there. 489A says, my lord, who counterfeits. I did not, my lord, FIR does not disclose that I counterfeits, my lord, or rather I manufactured it, my lord. And it is also it does not disclose in the FIR, my lord, that, my lord, it does not appear from the FIR, my lord, that, my lord, I have, my lord, I have an intention to sell it or circulating it, my lord. FIR says, my lord, only, my lord, some amount, my lord, fake currency has been recovered from my possession as well as the other request possession from the other request who has been enlarged on bail. And, my lord, thereafter there was a search made in his house, and from house, my lord, a bundle of papers are recovered, my lord, and thereby the police, my lord, presume that it will be used for the purpose of manufacturing the fake currency. But no printing machine, nothing, my lord, was recovered from the possession of, from the house of the accused person.
Yes,
lord.
any other material
My lord,
to
my lord,
support that he prepared or manufactured those fake Indian currency?
this reveals from the my lord, scan copy, my lord, and from the statement, my lord. His statement is also there, my lord. 161, my lord.
Mm.
It's admitted, my lord, regarding this, my lord. Lakshmi, I have
Maybe
trademark, my lord.
his confessional statement was not recorded.
Not relevant, but for the investigation purpose also, my lord, and others also, my lord.
Mm.
Here is also, my lord, 100 pieces could be recovered from their position, and same, my lord, same number, my lord, it was. Then thereafter, another, my lord, bundle suspected take 100 rupees. Thereafter, my lord, one bundle of white paper length so and so, my lord. 13
Length?
number small bundles white paper length so and so. One blue color Realme mobile. One light blue color Redmi mobile. That was recovered, my lord.
Whether those mobiles were used in manufacturing.
Far as
those-
that was used, my lord,
Mm.
for connecting different person, my lord. 3 mobile phones recovered. All of them switch off in condition, my lord.
Is
From the
it,
police, my
can it be an incriminating circumstance?
my lord. That may be, my lord, it is
Mm.
trial, but here I have the objection, my lord, here, strong objection, my lord. Here, 489B, 489C, and 489A, all of the sections were searched against him, my lord. And there is only 5 PWs, my lord, 1 examined, and next was, my lord, PW3, my lord, Basusa. He was present on that day, my lord, on 29/2, but they have taken time on that day, my lord. And therefore it could not be examined, my lord. And FSL also shows that there are fake,
No, Mr. Sharma.
my lord.
Okay, we are agreed that the fake Indian currency notes were recovered from his position,
My lord,
but that offense is bailable
my lord.
for
But
18 and C.
see,
But
my
do you have any other materials to show that he had prepared or manufactured said fake Indian currency notes?
lord,
Mhm.
that at this stage it is cannot be said, but here, my lord,
No, is there any material in the scanned copy of the record?
Then I will have to again verify, my lord, record, my lord.
You have to.
My lord,
Okay, you verify, then we'll take it up tomorrow.
my lord,
You verify.
my lord.
On the pair being made by Mr. B. Sharma, learned additional PP. Rest is list the matter tomorrow so as to enable Mr. Sharma to go through the scanned copy of the record. Mr. B. K. Sen, learned counsel for the accused present. Tomorrow.
Item 11,
Obliged, highly obliged.
item 11,
Right, Ms. Lordship.
Mm.
Well, application under section 430 and Chelsea. Allegation is under section 365.
My lord, here CD was called for, my lord, but one letter received from the IO, my lord, he prays for another date, my lord.
IO. This thus further submits that investigation of the case has almost been completed. Para, having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record and also perused the case diary with the assistance of Ms. Das, learned additional PP. It appears that the applicant has been cooperating with the investigating agency. And he appeared before the IO and his statement is also recorded. And further, it appears that the material part of the investigation is almost over. That being so, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore, the interim order dated 1/4/2024 is hereby made absolute in the same terms and conditions. Case there will be returned.
21,
Number 18, my lord, CD has not come, my lord. ET order is there, if we put it. Item 18.
Okay, after 1 week,
Interim we put.
till then interim order
Lordship,
passed earlier.
based on 14 of May, Lordship. 14 May,
14.
14 May.
Okay, 14.
Interim we put it. Obliged.
21,
This is second time, Lordship. Earlier rejection order, page 14. Second,
Page number?
14, 1, 4, start.
So what is the ground for filing this second application?
Lordship, earlier bill application, Lordship, the parcels received, the salar was not annexed, Lordship. The petitioner, the parcel, the buffaloes, Lordship. In fact, the buffalo is not incorporated in the Assam Cattle Preservation Act. So, Lordship, I purchased the buffalo. The three petitioners is the owner of 2 buffaloes, Lordship. There are 6 buffaloes, Lordship. Allegedly, they are trying to transport as per the affair in Bangladesh, Lordship. In fact, the petitioner purchased for the domestic use. I have annexed the parcel receipt, Lordship.
So you are the owner of two buffalo
Is
and you purchase it for the purpose of
Domestic
domestic use. And earlier you have not produced those documents.
yes, yes.
And that is the ground for filing this second application. Yes, madam. CD received.
City received, Lordship, and earlier, Lordship, your Lordship has perused the case diary and already, Lordship, in the earlier irrigation order, Lordship, is 16, Lordship, it appears that Lordship interim preliminary on the ground of 6 number of buffalo were seized and same were not incorporated under section 13(1)(16) of Assam Cattle Preservation Act. Further, it appears that pursuant to order dated 4/1/23, the applicant have appeared before the IO and their statement have been decoded, but perusal of their statement recorded by the IO reveals that they have not cooperating with the investigation agency. Moreover, the IO has collected sufficient incriminating materials against all the 3 applicant, Lordship. So custodial integration is necessary. Their statement recorded, they denied, Lordship.
So
They did
earlier,
appear-
the bail petition was rejected on the ground that you have not been cooperating with the investigating
Lordship.
agency.
Actually, what happened, Lordship, the
Hmm?
informant here is
Hmm?
a police person.
So, can it be a ground to grant you the privilege of bail,
So otherwise,
prior's bail on the basis of this purchase receipt?
otherwise, Lordship, they are ready to
Because,
cooperate, Lordship. Only Lordship in this matter, Lordship, only one aspect, Lordship. Only have the sections, Lordship.
no,
379.
now we are not concerned with the section and the receipts. We are concerned with the fact that you have not been cooperating with the investigating agency.
Otherwise, they have appeared, Lordship, their
Hmm.
statement has been recorded. And
No, they have
denied
appeared, that is
all-
a different thing, but
They flatly denied all the allegations, Lordship.
Lordship, otherwise, Lordship, the legal aspect, Lordship, only 353 is here attracted, Lordship, if the
Only?
affair is assumed to be true, Lordship.
Only?
Otherwise-
353.
Yes, Lordship.
The other section 379,
Yes, Lordship, I have the
411.
I have parcels receipt, Lordship. And no individual lost the affair, Lordship.
Only two Buffalo purchases.
So, madam, what is the stage of investigation?
Lordship, otherwise, Lordship, their statement recorded, Lordship, investigation.
No,
of the-
earlier.
Now the note of the is that investigation of the case is almost complete.
Almost completed.
Kindly consider on any condition.
Huh?
On any condition, Lordship.
Heard Mr. AZ Ahmed, learned counsel for the applicant, and also heard Ms. Enders, learned additional PP for the state respondent. This paragraph number 2, 3, 4, and 5. So page number 14. Mr. Ahmed, learned counsel for the applicant, submits that this is the second or third? Second prior's bail application referred by the applicant, and the earlier one being AB number 3984 of 2023 was dismissed by this court after perusing the case diary on 23rd 1 2024 on the ground that they have not been cooperating with the investigating agency. Further, Mr. Ahmed submits that on earlier occasion, the purchase receipt of the seized buffaloes could not be produced before the court below and also before the before this court and also before the IO, and that the applicants are ready to cooperate with the investigating agency, and they have already appeared before the IO and their statements have also been recorded, and therefore Mr. Ahmed contended to allow this application. On the other hand, Ms. and thus learned additional PP has produced the case diary before this court and submits that material part of the investigation is almost completed. However, Ms. Das has pointed out that on earlier occasion, the petition was dismissed on the ground of non-cooperation of the applicant with the investigating agency. Para, having heard the submission of learned advocates of both sides, I am carefully gone through the petition and the documents placed on record and also perused the case diary with the assistance of Ms. Das, learned additional PP. It is not in dispute that the applicants have appeared before the IO and their statements have also been recorded. It Also, no, further it appears from the case diary that material part of the investigation is almost over. And as such, their custodial interrogation, in the interest of investigation, seems to be not warranted here in this case. And therefore, this court is inclined to allow this petition. It is provided that in the event of arrest of the applicants in connection with Suksor PS case number 239 of 2023 under section so and so, they shall be released on years bail on their executing a bond of rupees 50,000 each with one surety of like amount to the satisfaction of the arresting authority. The above provision is however subject to the following three conditions. Last condition, they shall not leave the jurisdiction of Chief Judicial Magistrate South Salmora Mankasar without prior permission. Case there will be returned.
And give the orders.
Timing item 14.
My lord, I have received the instruction, my lord, he has appeared.
He
Good
appeared. Heard, Mr.
Yes, yes, Sohori.
Learned counsel for the applicant and also heard Mr. B. Sharma, learned additional PP for the state respondent. Thereafter, there's a page number 224. Para number 2 and 3. The learned counsel for the applicant submits that this court by order dated 1/3/2024 was placed to grant the privilege of interim period bail to the applicant and pursuant to the said order, he had appeared before the IO and cooperating with the investigating agency. And therefore, a contention is being made that the interim order dated 1/3/2024 may be made absolute in the same terms and condition. On the other hand, Mr. B. Sharma, learned additional PP, has produced the case diary before this court and submits that the statement of the applicant is not available in the case diary. However, Mr. Sharma pointed out that the case diary has not been updated since the month of February 2024, and this order and the interim order was passed on 1/3/2024. And thereafter, obtaining verbal instruction from the officer in such concerned PS, Mr. Sharma submits that the applicant had appeared before the IO and his statement is recorded. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents plus on record and also perused the case diary. With the assistance of Mr. Sharma, learned additional PP. It is not in dispute that the applicant had appeared before the IO and cooperating with the investigating agency. In considering above and also considering the nature and gravity of the offense, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to make the interim order dated 1/3/2024 absolute in the same terms and conditions. In terms of this evidence, dispose of CDV return.
Items 22 and 23 for orders.
Your lordship. But we have taken steps, lordship.
You know, definitely.
Your lordship, the appellant convicted under section 148, 149 and 324. For 2 years, lordship. And item 23, lordship, they have filed appeal against acquitting lordship under section 302, lordship.
Office note dated 18/4/2024 indicates that service report upon respondent number 2 is still awaited. What to do? You want to take crash step?
No, Lordship, as per recent notification, Lordship, in
No, this case was filed in the year 2023.
23, Lordship.
That notification is of this year, March. So it is prospective in nature. It cannot be applied retrospectively.
Await service code, Lordship, because we have
Okay,
taken step in February, Lordship.
List the matter on. Register list the matter on
13th May.
awaiting service report upon respondent number 2. Mr. Ayush Chaudhary, Learned Counsel for the appellant, and Mr.
Yes, Bolu.
S. Barua, Learned Counsel for the respondent number.
I'm for the petitioner.
In item 23, Lordship, they are the appellants, Lordship.
Acha. Mr. B. Sharma, Learned Additional PP for the respondent number 1 present. Okay.
24.
May it please your Lordship. Lordship, this is a application challenging the charge order. The respondent number 2 has already appeared, but the last order says interim will be considered after receipt of LCR. My lord,
LCR receipt.
Scan copy of LCR is not received, although it has order was of 1 month ago. Now the next date for the case is fixed on Friday, this coming Friday, 26. Now, what I suggest, my lord, since he has also appeared, this matter may be finally disposed till then, at least till then the proceeding may be stayed and a reminder for the LCR. Because he has already, respondent number 2 has already appeared.
I'm in, yes, I agree to the proposition, that may be done.
No, is it possible to get the order before the next date?
Yes.
No, to get the LCR?
LCR, my lord, order is there for scan copy. That is of 20th March, but till now it has not come. 25 years.
If we fixed on Thursday, your Lordship, you can take a chance on Thursday.
Thursday.
Scan copy of
The case is fixed on Friday.
Friday. Well, even if I get an order or if I get a stay order
No,
also on
if
Friday,
if we receive the LCR, we can finally dispose of the matter. It is against framing of charge order.
framing of charge,
So charge has been framed against you under
306.
section 306.
306. Or my lord, just May, in the month of May, first week of May, let it come, because otherwise even if I get a copy of Friday, even if a stay is granted to me on Thursday, I won't be able to get a copy or communicate it there. So let the LCR come, fix it on first week of May, and finally dispose it off, since he has already appeared in admission stage.
No, if you are not pressing upon your interim period, then it is okay.
The interim, because Friday is the
That's
next
okay,
date.
but
For some reason, if it does not reach on Thursday, I am trapped.
it may not be proper also to grant relief without going through the record.
Everything has been annexed here, my lord. Everything, every statement, every seizure list, everything has been annexed in the petition. With statement of all the witnesses, there are 3 seizure lists, the charge sheet, everything has been annexed, including the PM report.
So what is the ground?
My lord, my
How the impugned order suffers from infirmity?
my lord, first of all, there has to be an abatement on my part. That
And
amendment,
who are you?
I was supposed to be, I was having relationship with her. Father admits, mother admits. In fact, father and mother in their statement says they had been opposing our relationship. That is the first instance. Second instance, the brother says that younger brother, he says that before she committed the act, she was crying over the phone. But there's nothing on record to show I was the person who was talking with her at that point of time, even though our phones have been seized. So my calling her just prior to the incident, there's no materials, and now they cannot bring in anything else. And father and mother both say that they have opposed our relationship in their 161 statements. Although mother says something else, that there has been some photos of us going viral, but that also there's nothing. No additional witnesses come, although there are villagers nearby.
Whether those photographs have been seized here?
Nothing. If your lordship sees the charge sheet, there are only few documents. That is sketch map, postmortem report, 3 seizure lists of my phone, her phone, and the gamucha she used. That's all.
Even phone was not even sent for FSL, nor the CDRs were collected. Call data records. My
Yes, Mr. Devi.
In my respectful submission, Your Lordship, the lower court record may be required
Pardon?
before a final disposal. The
Pardon?
LCR may be required, Your Lordship, before a final disposal. I need, well, I also need to get some instructions, Your Lordship. I mean, just engage, I got to the file. But I also need some instructions, Your Lordship. With respect to the photographs that went viral, Your Lordship, I need those instructions. The photographs were.
So then let us fix it on Friday, no, on Thursday.
Yes, Your Lordship, I'm ready. I'll take the instructions. LCR to here, sir.
If for some reason Thursday does not end, then stay may be granted because Friday is the next date. That is the only issue. Let it come up on
No,
Monday.
no, for what purpose the case has been fixed on?
Evidence, for evidence. It has been fixed. My lord, the impugn order is of 3rd of February. I had moved this petition in March. Order is of 20th March. LCR was called for. But till now it has not come. And that was scan copy of the LCR.
No, even if on that day, on Friday, some witnesses are examined, how you will be caused prejudice?
There's one thing I would say that my defense will be out. If I put something there, my defense will be out. My cross-examination is my defense. So why should I disclose my defense? When this,
So that is not the ground for staying the proceeding.
that's what I'm saying, my lord, for just one instance, let it come up on first week of May. Till then, the LCR will also be here. We'll dispose it of in the admission stage. Just one date I'm seeking to postpone the proceedings.
Yes, Devi, any objection?
No, this, Your Lordship, but if he is only praying for a single date, then that on that particular day, he may file an representation, Your Lordship, praying that there should be an adjournment. Question of granting the stay, this stays, Your Lordship, that is what I am praying for. He may pray for a stay, he may give a petition before the court, seeking an adjournment on that day.
That can be done, but who knows what costs may come, you never know, because witnesses may come. I am told 2 witnesses will be called. So maybe I'm assuming father and mother.
May I
Or
suggest,
Mr.
May I suggest, Your Lordship, it may be fixed on Thursday. Okay, the LCR will come because it's a scan copy only. And maybe disposed of.
Okay, let us try on Thursday then. Heard Mr. D.K. Bhattacharya, learned counsel for the petitioner, and also heard Mr. T. Devi, learned counsel for the respondent number 2, Mr. D. Sharma, learned additional PP for the respondent number 1. Mr. Bhattacharya, learned counsel for the petitioner, submits that by the order dated 28/3/2024, LCR was called for, but the same has not yet been received. But Mr. Bhattacharya further submits that next date of the case has been fixed before the learned trial court on Friday,
26/4.
on 26/4. And as such, there is some urgency. And he contended to hear the matter. No, here on the pair of interim, here on the interim pair without LCR, and that he has enclosed all the relevant documents along with the petition. On the other hand, Mr. Devi, learned counsel for the respondent number 2, submits that without LCR, he is not ready to argue the matter, and he also needs some instruction from the respondent number 2. Under the aforementioned facts and circumstances, it is provided that Resisa leaves the matter on Thursday and issue urgent reminder to the learned court below for transmitting the scanned copy of the LCR. Scan copy of the LCR without further delay, list accordingly.
Deeply obliged, Your Lordship.
33.
Well, otherwise, both the accused persons are released, my lord. They have undergone the sentence, my lord. The instructions are there with the land court prosecutor, my lord. Now, my lord, either the paper book has to be prepared and the appeal has to be heard on merits. But, my lord, the only problem which I could see from the orders, my lord, appeal was prepared on 19/3/2020, my lord. By the time, my lord, the registry did not release the matter, records came up, my lord, the paper book was, so, my lord, by the time the time elapsed, my lord. And now
No,
they
no,
are free.
the appellants were convicted under section 5 of the Explosive Substance Act. No, whether paper book is required to dispose of the petition on merit.
My lord, otherwise I would not be in a position to argue the matter.
You
As
can
an
go to
amicus
the
and
record, we'll furnish the,
My lord,
Yeah,
in that case, my lord, I'll do that. In that,
I will allow you to go to the record.
if my lord, photocopies are my lord, given to me, my lord, in that case, my lord, I'll be able to.
Photocopies,
Yes, my lord. Being a amicus, my lord,
photocopies of the witnesses,
my lord, the case records, my lord, case record, my lord.
case
The
record.
learned case records, my lord. Or otherwise, my lord, since it was a jail appeal, they have been released, my lord. The jail appeal becomes infractuous because it was preferred while they were in custody, my lord. Now, if they want, they can come down, my lord. That part is a separate, my lord.
No.
Because as far as merit part is concerned, since they have preferred an appeal, my lord, it should be heard on merit, it should be disposed of on merit. That is the law, my lord. But otherwise, my lord, since they were in jail, they preferred from the jail, and by the time they were, and now since, my lord, one has been released on 2021, my lord. So he did not bothered about the appeal, my lord. The other one was freed on 15/4/2022. Thereafter, he was also not bothered, my lord. That means they are hardcore criminals because, my lord, did not.
Yeah, maybe, but we'll dispose of it on merit.
Merit, my lord.
We will
Only
hear you.
copies of the case record will furnish.
Entire case record.
Judgment and the witnesses and the appeal, this much.
Okay. Person to heard Mr. A. Tiwari, learned counsel for the learned legal aid, learned amicus curiae for the appellants, and Mr. B. Sharma, learned additional paper for the state respondents. Person to order dated 19/4/2024, Mr. Sharma has obtained necessary instruction from the Superintendent District Jail Defoe in respect of releasing the convicts, releasing the appellants, namely Babul Singh Lekhte and Sri Subdal Doulagapo from the district jail Defoe on completion of their conviction term. No, on completion of their terms of imprisonment. And it appears that both the appellants have already been released from jail. Though Mr. Tiwari, learned amicus curiae, submits that since this appeal has been preferred from jail, the same become infractious on account of release of the appellants from the jail on completion of their terms of sentence. Yet this court is inclined to hear and dispose of the appeal on merit. Mr. Tiwari further submits that in that event, he may be furnished photocopies of the relevant documents, such as the copy of judgment and the statement of witnesses and the FIR and the search sheet, and also the also the search. Accordingly, it is provided that Registry shall furnish the aforementioned copies to the Xerox copy of the aforementioned documents to Mr. Tiwari well in advance and list the matter on
9th May, Thursday.
sorted.
7th May.
7 May, there will be election.
Elections at
Oh, sorry.
One notification has already been issued.
2nd May.
Second.
Thursday.
It will be too early, my lord. Second, my lord,
Hmm.
because time is very short, my lord. I need to go through all the,
Thursday was
because the
Tuesday was a-
registry will give that.
Oh,
Seventh
hearing
was-
matter. Oh,
Ninth was seventh of Tuesday.
Ah.
Ninth is 20. On second May is.
okay, ninth.
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 Deeply obliged, your lordship.
For hearing, item number 26. 26.
May it please your lordship. Your lordship, I'm appearing on behalf of the amicus curiae, Mr. P. Mahanta.
On behalf of
Mr. P. Mahanta, the amicus curiae.
Mr.
Lordship, P. Mahanta.
So this is Parthard matter.
Yes, your lordship. I'm praying for a short accommodation in the matter, your lordship. He is indisposed today.
Miss, your good name?
Miss C. Das, your lordship.
D.
C. Das. C for
C.
Patrick.
Das. Learned counsel appearing on behalf of Mr. P. Monto, learned amicus curiae. For the appellant, price for listing the matter on
Next week, your lordship. Any day next week.
Right.
9th May.
Yes, your lordship.
9th May. Yes. Due to some inconvenience, so Mr. P. Monto, the learned amicus curiae, could not turn up today. There is accordingly allowed, rest is list the matter on 9th May
Highly your pleasure, your lordship.
as parted.
27.
Wait, please, your lordship. This case, your lordship, I'm convicted under section 376. And 420 and 506 of the Indian Penal Code. I'm sentenced to undergo imprisonment for 8 years, your lordship. I've already undergone a period of 4 years, 3 months, 7 days. The paperwork is there, your lordship. It's a very small matter if your lordship allows me to.
Small matter, but time is very short.
Then it will be fixed up to some other day.
And what is the ground, by the way?
Lordship, there is a delay in filing the FIR first. And secondly, there was the consent, your lordship. In my respectful submission, there was consent on the part of the victim. She was pregnant. And after a period of 6 months, they have filed the FIR, your lordship. Yet, on the basis of the statement of the victim, the court came to a finding that I am guilty and I was convicted and sentenced to undergo imprisonment for 8 years, your lordship.
So when the occurrence took place?
The occurrence, your lordship, December 2017. The dates are not there. December 2017. And they had filed the FIR on 28/5/2018. After a period of 5 months.
So what material do you have to establish that the victim is a consenting party?
Your lordship, may kindly peruse the statement of the victim, your lordship. She is 28 years old. She is not a young woman. She has stated the facts that married, your lordship.
But it appears that you have threatened her
Yes, your lordship. Yes,
and you have threatened her to make her cripple
true, your lordship. But she could have.
by your quackery skill.
Yes.
Hmm?
The delegation is definitely there, your lordship.
Hmm?
But she remained completely silent. It was only after a period of time.
Her evidence is at page number?
Our evidence is at page number 12, your lordship. Of the paper book, I'm sorry, your lordship.
Yes. Who lost the FIR?
The father, your lordship.
Father.
Father, the FIR is at page 4.
Uh, so there is explanation.
But your
Closing of FIR got delayed as you are waiting for the visa in the village.
If you lordship kindly peruse page number 17, the prosecution witness number 4.
Page number?
17, your lordship, of the paper book. The prosecution witness number 4, your lordship.
Yes.
As this is Vital Maharaj, he states, second line, your lordship. The incident took place about 2 years ago. There was an illicit relationship between Renuka and the accused. Renuka's father informed the villagers and asked for a bichar. In the bichar, both the boy girl admitted the incident. The accused refused to accept Renuka and offered to pay an amount of rupees 3,000 as fine. The accused took 1 week time, but later he fled from the village. In the cross-examination states, I did not say to the police that Melason Marak was a quack. I was present in the meeting. Some 50 to 60 people were present in the meeting, which was held in a playground.
No, who is this PW4?
PW4 is an independent witness, your lordship. Is an independent witness, your lordship.
Independent witness.
Yes, your lordship.
So how does
He
evidence of this witness will help you?
No, he admits the fact that in that particular place, when there was a bichar, your lordship, they have admitted that there was a illicit relationship between them. So
Hmm.
that means there was they were consenting parties, your lordship. She was 28 years old at that point of
No,
time.
maybe she may be of any age, but
So her statement, your lordship, I am also relying on some.
admission to what respect? Admission in commission of this rape or admission in respect of having relationship?
This is what I understand, your lordship. There was an illicit relationship between Renuka and accused. In my understanding, your lordship, that means they are having a consensual relationship. That is what I understood, your lordship.
But is there any other material to suggest the same?
Her statement itself, your lordship,
Which one?
the statement of PW2, your lordship.
Hmm.
In our cross-examination, Your Lordship may kindly
Hmm.
see. The last paragraph, in the first paragraph, last line, Your Lordship.
Hmm.
I did not raise any alarm as the accused resisted me from doing so.
Where?
In the last line, Your Lordship.
Huh.
The first paragraph of the cross-examination part.
Huh.
There are people in the house of the nephew of the accused. I did not raise any alarm as the accused resisted me from doing so.
Yes.
This is one part, Your Lordship. So she has not raised any alarm. And secondly, Your Lordship, in the
No, there is explanation as the accused resisted me.
yes, sir. But
It is the cross-examination.
yes, Your Lordship.
Hmm.
In the chief part, Your Lordship, may I read?
Hmm.
From the line noticing, Your Lordship, is the last part of the page number 12.
Yes.
Noticing my physical appearance when my Jethima, aunt, elder sister, or father or mother, wife or father's elder brother, Nimki Sangma questioned me, I told her about the incident and that the accused had committed rape upon me. At that time, I was carrying a pregnancy of 3 months. My parents came to know about the incident from my Jethima. So 3 months she kept quiet, Your Lordship. There were other people also in and around the village. She had not stated anything to anybody.
That's all right, but did you put any question in cross-examination or why she has not disclosed the fact to her parents or any other else?
No, Your Lordship.
Then
The question that I put was, this was the answer, Your Lordship. There are people in the house of the nephew of the accused. I did not raise any alarm as the accused resisted me from doing so.
from where you were reading?
From the same line, Your Lordship, in cross-examination,
Hmm.
the last line, Your Lordship.
Hmm.
The from the last in the paragraph, first paragraph, Your Lordship, third line.
Hmm.
The house of the nephew of the accused is situated near that of the accused. There are people in the house of the nephew of the accused. Said Your Lordship got there, Your Lordship.
Maybe.
I did not raise any
This
alarm.
explanation is there. I did not raise.
Yes, Your Lordship. Except her statement, Your Lordship, no other statement. There is no other statement.
No.
And this statement of PW I know,
Where is the question?
Yes,
of-
yes, I
of presence
understand, Your
of
Lordship.
independent
I understand. That is why, Your
Huh?
Lordship, I'm relying on a Supreme Court judgment, Your Lordship.
Ah.
2015, 2008-15 SCC 133.
Hmm.
Only one paragraph I will read.
Hmm.
This was a case of gang rape, Your Lordship.
Hmm.
Para 11. It
Hmm.
cannot be lost sight of that rape causes the greatest distress and humiliation to the victim, but at the same time, a false allegation of rape can cause equal distress, humiliation, and damage to the accused as well. The accused must also be protected against the possibility of false implication, particularly where a large number of accused are involved. It must be be borne in mind.
Mr. Deuri,
This is, I'm only on the principle, Your Lordship. I'm only on the principle.
no, where is the question for disbelieving the version of the victim because she is already pregnant?
Yes, sir. I'm not denying it.
Hmm.
Your Lordship, only another judgment. This is 2008-14 SCC, Your Lordship.
Hmm.
This is with respect to a pregnancy, Your Lordship. Also. This case is very similarly situated like my case, Your Lordship.
Hmm.
Para 5.
Hmm.
The present case only depends upon the testimony of the prosecutrix. The incident in the present case took place 7 months prior to the date of lodging the complaint, as a realization dawned upon her that she has been subject to rape by the appellant accused. No complaint or grievance was made either to the police or the parents prior thereto. The explanation delay in lodging the FIR is that the appellant accused promised her to marry before the FIR was not filed. In cases where the sole testimony of prosecutor is available, it is very dangerous to convict the accused, especially when the prosecutors could venture to wait for 7 months for filing the FIR for rape. This leaves the accused totally defenseless. Had the prosecutors lodged the complaint soon after the incident, there would have been some supporting evidence like the medical report or any other injury of the body of the prosecutrix so as to show the sign of rape. If the prosecutrix was willingly submitted herself to sexual intercourse and waited for 7 months for filing the FIR, it will be very hazardous to convict on such sole oral testimony. Moreover, no DNA test was conducted to find out whether the child was born out of the said incident of the rape and the appellant accused are responsible for the said child. In the face of lack of any other evidence, it is unsafe to convict the accused. Therefore, we are of the opinion that the view taken by the trial court and the learned singers of the High Court in convicting the appellant accused under section 373 IPC cannot be sustained.
Hmm. I don't think that this ratio laid down in this case also come into your rescue because in the present case the victim is pregnant. The medical evidence has already established it.
But your lordship, the DNA was not done.
DNA was not done, that's all right, but
Here also she
in
was
all the
pregnant.
cases it is not necessary to conduct DNA.
Here also she was pregnant.
And did you made any peer before the IO or before the learned court below to conduct DNA test? No.
No, no. Fine, sir.
How can you raise this issue before this
No, I'm just-
appellate court then?
That is why your lordship, not, I'm on the DNA, I'm on not only the DNA also, I'm on the pregnancy part, because the court has very categorically stated in this judgment that
Hmm.
even if she is pregnant, she could have very well come and filed a case on the
Hmm.
very day she was raped or after some time,
Hmm.
after a few days. She didn't do that, your lordship. She waited for a period of 5 months.
Hmm. So, Mr. Devri, you produce one judgment
Yes, sir.
before this court in a state of Punjab versus Gurmeet Singh.
Yes, yes, it's there, your lordship.
You produce that judgment before this court on next day,
Yes, sir.
and thereafter you argue the point of this delay, and also on this point of believing the statement of the sole witness, that is the victim.
Definitely.
Hmm. Heard Mr. T. Devi, learned counsel for the appellant, and Mr. B. Sharma, learned additional people for the state respondent. Whether notice was served upon the respondent here,
Notice, yes, your lordship, they, Melissa Mark, it was served, your lordship,
sir.
but they did, nobody appeared, your lordship. That is.
Is it necessary to appoint someone as amicus curiae? Because there should not be any lacuna on the part of the court.
She may appointed. Yes.
Charges frame under section
My lord,
376.
376.
376.
Recently, one notification was issued regarding you see the notifications?
But in the such type of offenses, my lord, 376 POCSO.
No, POCSO is not here
POCSO is not here.
because the age of the victim is
Right.
28
Right,
years.
right.
So, is it the requirement to engage any amicus curiae in absence of the respondent number 2?
Informant.
Whether she was implicated here
Yes, your lordship, we have made her a party.
as respondent number 2, and notice was served upon her.
Notice was sent, nobody appeared, your lordship, that is why.
No, send means sent is different thing and serve is
Served,
different thing.
I believe served, your lordship. Served or returned unserved, I'm not very sure about it. Unanswered, I think it's unanswered, I don't know.
Okay, you go through the record. You submit on next set.
Fine,
List
yes.
on when?
Second. 14th.
14 May.
Deep please.
Which service you go to? For which service you go?
মানে এটা আগো গোটে হাইয়েন না পিস করা গোটে এটা ঠিক করে জানো আমি হেন পিস করব মানে গোটে এদিকে পিস করিছে যাতে
That's all, no?
না এটা অলরেডি শাসন আমার আবে ছাবে তো মানে তো মোস্ট প্রবলি এটা আমি তুই করা হিয়ারিং অফ পিস নিউ কি আইছে মই তো মাথায় মারা নাই মানে এগুলা কাছে কি যদি হিয়ারিং অফ পিস করা হয় না
আপনি জানেন 3 মাসের মধ্যে